Welcome to AKS IAS Academy. Today, we will discuss the monthly current affairs magazine of July. Here, in this video lecture, we will discuss about the polity and governance related current affairs for the month of July. This monthly current affairs magazine is available as a soft copy on AKS IAS Education mobile app for download. So, first let us look at the index for the polity and governance. If you look at the various topics which are being covered in this magazine, number one, it is the Supreme Court to hear petition on nation's name. Next is the Supreme Court push to improve rule of law index. The third topic is related to decriminalization of adultery. Another topic that we'll be dealing with is the reservation is not a fundamental right as told by the Supreme Court. Next, we'll also deal with catalyzing online dispute resolution in India. We will then deal with Essential Commodities Act, PM CARES, and the Commission to examine sub-categorization within OBC reservations. And lastly, we will deal with the second capital of Uttarakhand, which was promulgated recently. Now let us get into the details of the topics. So the first topic that we have to discuss is regarding Supreme Court to hear petition on nation's name. What is the context of this? The Supreme Court will hear a plea which has sought a direction to the center to amend the constitution and replace the word India with Bharat or Hindustan, claiming that it will instill a sense of pride in our own nationality. The plea has sought a direction to the government to take appropriate steps to bring amendment in Article 1 of the Constitution. What is Article 1 of the Constitution? It says that India, that is Bharat, is a union of state. Okay. This deals with the name and territory of the union to the effect that the same refers to the country as Bharat or Hindustan, unlike India. The plea filed by a Delhi-based man has claimed that such an amendment will ensure that the citizens of this country get over the colonial past. So the person who filed this petition is saying that India is not a name indigenous to India. This was a name given by the Britishers to India. So that's why this petitioner says that we have to amend the constitution stating that the actual name is Bharat or Hindustan. The removal of the English name, though appears symbolic, will instill a sense of pride in our own nationality, especially for the future generations to come. In fact, the word India being replaced with Bharat would justify the hard fought freedom struggle by our ancestors that was being claimed by the petitioner. Referring to the 1948 Constituent Assembly debate on Article 1 of the then draft Constitution, the plea said, even at that time, there was a strong wave in favor of naming the country as Bharat or Hindustan. The petitioner also sees that the time is ripe to recognize the country by its original and authentic name, that is Bharat, especially when our cities and several states have been renamed so as to identify with Indian ethos. So that was about the article. The next important item in the month of July was the Supreme Court to push improvement of rule of law index. What is the context for this? The Supreme Court has asked the government to treat a writ petition for setting up expert panels to boost India's prospects in the rule of law index. Why is this a news actually? The cause of action for the petition accrued when the World Justice Project, please remember this. So, here, from the prelims perspective, you have to try to know what is this World Justice Project, when was it established, and what are the different indices that this project envisions, and what are the various modalities of the same. So, this World Justice Project ranked India in the 69th position in the rule of law index. India has never ranked even among the top 50 in the index, but successful governments did nothing to improve the international ranking of India, said the petition. So, the poor rule of law in India has a devastating effect on various rights such as right to life, liberty, economic justice, fraternity, individual dignity, and national integration. So, what is this rule of law index? The rule of law index is a quantitative assessment tool by the World Justice Project. So, there could be a question in your prelims examination giving you various options, asking you which among the following organizations gives the rule of law index, and there could be various options among which World Justice Project is the right option. So this is designed to offer a detailed and comprehensive picture of the extent to which countries such as India and several other countries adhere to rule of law in practice. So, what are the parameters on which the rule of law performance is measured? There are eight factors, namely the constraints on government powers. See, there is a saying which says, absolute power corrupts absolutely. So, in the same way, so as to limit the tyranny of the government, there should always be a restraint or a constraint on the government which is constitutionally and legally mandated. For instance, in India, the Constitution of India guarantees fundamental rights to the citizens. So these fundamental rights act as constraints on the government's powers. The next factor is absence of corruption. Then, the third important factor is the openness of government, that is, the transparency. Next is the fundamental rights, whether fundamental rights are existent in a country, whether they are being implemented in true letter and spirit. Next is the order and the security. How are the security measures? How is the security of the citizens guaranteed in the country? So that is one of the important parameters to measure rule of law. Next is the regulatory enforcement. In India, you have various regulatory agencies like the TRI, the SEBI, and likewise these are various regulatory agencies which look at the enforcement of various rules and regulations. Next is the civil justice, how it is evident. Okay, so, and the final important factor is the way the criminal justice is implemented in a particular country. So these are the various parameters on which the rule of law performance is measured. So now let us look into what is this World Justice Project. It is an international civil society organization. Okay, mind it is not a statutory or a constitutional body, but it is an international civil society organization with the stated mission of working to advance the rule of law around the world. It is a non-profit organization headquartered in Washington in the United States of America. Please remember this, ladies and gentlemen. It works through three programs, namely research and scholarship, rule of law index, and engagement. Its objective is to increase public awareness with respect to rule of law. It also seeks to stimulate government reforms and to develop innovative programs at the community level. Now, let us look into the next topic, that is the Supreme Court refuses to review the decriminalization of adultery. Let us understand the context of this. A five-judge review bench led by Chief Justice of India Sharad A. Bobde upheld a September 2018 constitution bench which had struck adultery out of penal statute book. What is the background of this? Let us look into it. The original judgment in the year 2018 was by a constitutional bench led by the then Chief Justice of India, that is Deepak Mishra, which had noted that Section 497, that is adultery of the Indian Penal Code, cannot command married couples to remain loyal to each other for the fear of penal punishment. two individuals may part if one cheats, but to attach criminality to infidelity is going too far. The court also observed that there was no data whatsoever to support claims that abolition of adultery as a crime, would result in chaos in sexual morality or an increase in instances of divorce. So, the original judgment in 2018 was based on the writ petition filed by a resident of Kerala, Mr. Joseph Shine. The bench has also held that Section 198(2) of the CRPC, which gave the cuckolded husband the exclusive right to prosecute his wife's lover, was manifestly arbitrary. On the other hand, the verdict had said that adultery can, however, be a ground for civil remedy, like the dissolution of the marriage. So, let us look into what was this Section 497, which dealt with adultery, which was repealed. Whoever Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man, without the consent or connivance of that man, such sexual intercourse, not amounting to the offense of rape, is guilty of the offense of adultery and shall be punished. In such cases, the wife shall not be punishable as an abettor. So here you see, it treats a married woman as a commodity of her husband. Adultery is not a crime if the cuckolded husband connives or consents to his wife's extramarital affair. So in this law, if you see, the onus of claiming that a particular person has committed adultery, that a woman has committed or indulged in adultery, is just based on the discretion of the male or the husband of that woman. The provision is the reflection of social dominance of men prevalent even 150 years ago to the present times. The next important article related to polity is reservation is not a fundamental right as said by Supreme Court. Recently, the Supreme Court has said that reservation of seats provided to certain communities is not a fundamental right. Now, let us look into what are the further details of this. All political parties from Tamil Nadu had filed a writ petition in Supreme Court seeking direction to the center to implement 50% OBC, that is the other backward class reservation, in the all India NEET examination seats surrendered by the state of Tamil Nadu. They have accused the center of violating the right of the people to have a fair education by neither implementing the 50% quota for OBCs in Tamil Nadu nor providing the 27% reservation for OBC candidates in other states for the All India quota seats. However, the Supreme Court pointed that a writ petition under Article 32, that is the right to constitutional remedies of the Constitution, can be filed only in case of violation of fundamental rights. Please remember this fact, ladies and gentlemen. This could be a potential question in your prelims examination. Okay, whether the writ petition can be invoked under Article 32 for violation of other rights or whether it can be invoked only in case of violation of our fundamental rights. Please focus on this. The court observed that the right to reservation is not a fundamental right. Okay. Earlier, the court had ruled that reservation in promotion is not a fundamental right. Okay. In the earlier judgment of the Supreme Court, it ruled that reservation is not a fundamental right regarding promotion in government jobs. However, in this recent judgment, Supreme Court has made it clear that reservation is not a fundamental right. The reservation per se itself is not a fundamental right. So, the fundamental rights, as you all know, have been classified into six categories, namely right to freedom, right to equality, right against exploitation, right to freedom of religion, cultural and education rights, and right to constitutional remedies. So these are the rights, that is, the fundamental rights, are mentioned in Part 3 under Articles 12 to 35 of the Indian Constitution. So, what are the constitutional provisions related to reservation in education and jobs? Various provisions in Article 15 and 16 of the Constitution empower the state to make special provisions in education and jobs, respectively, for the socially and educationally, please remember this, socially and educationally backward sections of the society and the economically weaker sections of the society. So, this is a rational and moral basis for reservation. That is, a particular section of the society should be socially, educationally, and economically backward. Only then that reservation is constitutionally, historically, and legally applicable. Although these provisions are mentioned in Part 3, that is the fundamental rights of the Constitution, their nature is like directives to the states, that is, they are not binding on the state. Now, let us look into what is this. The Scheduled Caste and Scheduled Tribe Reservation. The state, that is both the central government and the state government, is permitted to make any special provision for the advancement of scheduled castes and scheduled tribes. For example, reservation of seats or fee concessions in public educational institutions, and providing reservation in government jobs if those particular castes and tribes are not adequately represented. Please, this is the catchword over here. The quota for scheduled castes in India is 15% presently, and for the scheduled tribe population is 7.4% presently. So this reservation has been provided because these communities, let it be the scheduled castes and scheduled tribes, have been discriminated and subjected to historical injustices due to the prevalent evil caste system in India. So, now let us look into the OBC reservation and its status in India. The state, that is both the central and state governments, are empowered to make provision for the advancement of the other backward classes regarding their admission into educational institutions and government jobs. The quota limit, however, for the OBCs is only 27%, that is the maximum ceiling. However, various state governments have different quota limits for their OBCs in their particular state. For example, Tamil Nadu has provided 50% reservations to the OBCs owing to their population of OBCs, and they have used ninth part of the constitution so as to protect their policy of reservation. Part 9 of the Constitution. However, in the Indra Swahane 1992 judgment, the Supreme Court fixed the upper limit for the combined reservation quota should not exceed 50% of the total seats. Recently, reservation has also been provided to the economically weaker sections. The 103rd Constitutional Amendment Act of 2019 empowers both the central and state governments to provide 10% reservation to the economically weaker sections of the society, that is, apart from the OBCs, SCs, and STs, the so called quote unquote general category population, which is economically weaker, will be eligible for 10% reservation based on certain criteria which is laid down by the government for the government jobs and educational institution admissions. So, what is Article 32 of the Constitution? This article of the Constitution deals with the enforcement of the fundamental rights. Enforcement. As per this article, an individual can directly approach the Supreme Court if his or her fundamental rights are violated. The Supreme Court has power to issue various writs, namely mandamus, quo warranto, certiorari, prohibition, habeas corpus, and likewise for the enforcement of the fundamental rights. So, through this Article 32, an aggrieved citizen whose fundamental rights have been violated can approach the Supreme Court only if his fundamental rights are violated. If his rights are violated and they are not fundamental rights, he can also approach the High Court. The Parliament also has the power to empower any other court to exercise within the local limits of this jurisdiction all or any of the writ issuing powers of the Supreme Court. So it is the sole discretion of the Parliament if it wants to empower any other court to exercise this jurisdiction. This Article 32 can only be suspended as per the constitutional provisions. Okay. The next important news article in the month of July 2020 was dealing with the catalyzing online dispute resolution in India. Recently, the Niti Aayog, in association with Agami and Omidyar Network India, brought together key stakeholders in a virtual meeting for advancing online dispute resolution in India. What are the key points in this? Senior judges of the Supreme Court, secretaries from key government ministries, and leaders of the industry, legal experts, general counsels of leading enterprises participated in this summit. The common theme of the meeting was a multi stakeholder agreement to work collaboratively to ensure efforts are taken to scale the ODR in India. What is this online dispute resolution? Let us look into this. It is the resolution of disputes, particularly small and medium value cases, using digital technology and techniques of alternative dispute resolution (ADRs), such as negotiation, mediation, and arbitration. So these are, see, whenever there is a particular conflict or some legal tangle, we usually approach the district court or the high court, and if the issue at disposal is a major issue, we approach the Supreme Court. However, in the Indian context, we see the courts are overburdened with a lot of backlog cases. Okay, so that's why we have this method called alternative dispute resolution mechanism, which comprises of various techniques like negotiation, mediation, and arbitration, so as to resolve the disputes between the conflicting parties. So, this online dispute resolution also utilizes information technology to carry out ADR. The information management and communication tools in ODR may apply to all or part of the proceedings and also have an impact on the methods by which disputes are being solved. So, what is the status of ODR in India? The United Nations Commission on International Trade Law, that is UNCITRAL, adopted the UNCITRAL Model Law on International Commercial Arbitration in the year 1985 and the UNCITRAL Conciliation Rules in 1980. The United Nations General Assembly has recommended the use of the said model law and rules in cases where a dispute arises in the context of international commercial relations and the parties seek an amicable settlement of the dispute by recourse of conciliation. So, India has also incorporated these uniform principles of ADRs in the Arbitration and the Reconciliation Act of 1996, which had been amended several times to match these changing circumstances. The Arbitration Act provides for ADR mechanisms like arbitrations, conciliation, and negotiation for national and international stakeholders. What are the advantages of this online dispute resolution mechanisms? See, more importantly, it is convenient, accurate, time saving, and cost saving. It provides more efficient, effective, scalable, and collaborative mechanisms of containment and dispute resolution. What is the significance of such a move? It will set into motion the use of technology towards efficient and affordable access to justice, especially in the post corona times. During the ongoing COVID 19 pandemic, the target is to look into the COVID related disputes, mostly related to lending, credit, property, commerce, and retail through ODR, which is an important part of the economic revival. In the coming time, ODR could be the mechanism that helps with achieving expedient resolution. However, what are the challenges to such a kind of mechanism? Well, arbitration was intended as an alternative to going to court for certain kinds of disputes. That mechanism itself has become cumbersome and often expensive. Lack of enough arbitrators and building trust among consumers is also a major limitation for this. Dealing with people who are not used to the digital ecosystem is also a major roadblock in the implementation of ODR. So, how can we improve this scenario? The various suggestions are: the private ODRs and ADR providers need to be added into the system so as to ensure that online resolution can reach different industries, locations, and parts of the country and also support the public institutions. Making the online dispute resolutions voluntary will defeat the purpose, so it should be made mandatory, okay, for specified categories of disputes, and it should cover about 3 sessions so that parties don't feel that it is a mere formality. So, more recognition should be given to the online redressal processes so that its idea reaches people and they can use these online processes. Now, let us look into what is the way forward for this issue. There needs to be a fundamental change in the mindset of the people to separate the idea of justice from the place called court. So, here, the author says that there should be a fundamental change in the mindset of the people so that they accept that there is an alternative mechanism to dispute resolution rather than the courts. Also, the multi stakeholder exercises need to be undertaken to achieve this in a sustainable, efficient, and collaborative manner for the transformation of justice delivery across various facets. The future will be a hybrid model that combines the best of real and virtual worlds. People need to reimagine the whole process of justice delivery to work in the hybrid system where real and virtual world are combined so as to provide effective, efficient, and affordable justice delivery to the citizens. Next is the Essential Commodities Act. What is the context for this? The Union Cabinet has approved an ordinance to amend the Essential Commodities Act 1995 to deregulate commodities such as cereals, pulses, oilseeds, edible oils, onions, and potatoes. What is this Essential Commodities Act? Enacted way back in the year 1955, the Act empowers the government to regulate the production, supply, and distribution of a whole host of commodities it declares essential in order to make them available to consumers at fair prices. So, this Act empowers the government to regulate the production, supply, and distribution of certain commodities that it declares essential so as these commodities, which are very important for the consumers, are affordable and there is no horse trading regarding this commodities. Under the Act, the government can also fix the maximum retail price, that is the MRP, of any packaged product that it declares an essential commodity. So, in a way, the government puts a ceiling on the price of that particular commodity so that the various hoarders or the market middlemen do not take advantage of the supply limitation and hoard the prices so as to make them unaffordable for the people. The list of items under the Act include drugs, fertilizers, pulses, edible oil, petroleum, and petroleum products. The center can include new commodities as and when the need arises and can remove them from the list once the situation improves. The need for the amendment in the Essential Commodities Act. So, what was the need that the central government took such a decision recently? So, the different background of enacting the Essential Commodities Act, let us look into it. The Essential Commodity Act was legislated at a time in India when the country was facing scarcity of food due to the persistent abysmal level of food grain production. So, after independence, India had limited resources when it comes to technology or the various mechanisms to exploit the natural resources. India had limited resources so as to tap the true potential of our resources. So the country was dependent on imports and the assistance from you know major countries like United States of America, such as India used to import wheat from US under the PL 480 program to feed the population of India. In this scenario, to stop the hoarding and black marketing of the food grains and foodstuff, the Essential Commodity Act was enacted in the year 1955. See, the simple logic is, as there was limited supply of wheat or some kind of essential food grains in the Indian market, there were imports. And also whatever limited, production that was taking place in India, this was being the cost of the such grains and foodstuff was escalated due to black marketing and hoarders and the middlemen. So the unintended outcomes of this act was, while the purpose of the act was originally to protect the interests of consumers by checking illegal trade practices such as hoarding, it has now become a detriment for investment in agricultural sector in general and post-harvesting activities in particular. See, though the intention of this particular statutory act was, positive in nature, so as to make the commodities available to the consumers at an affordable cost, this has somehow inhibited the investment into the agriculture sector. So, what is the change in situation now? According to Ministry of Consumer Affairs, Food and Public Distribution, the production of wheat has increased by 10 times compared to the 1955 to 56 level. Rice production has increased more than 4 times. Okay. Also, pulses production has increased by 2.5 times compared to 1955 to 56 levels. India has now become an exporter of several agricultural products, stating that, there is a sense of self sufficiency and the output of essential food grains and foodstuffs has increased to a great extent. So, with these development, the Essential Commodities Act has become anachronistic. Okay, so various amendments have been made to Essential Commodities Act. So, there was an introduction of a new subsection, namely Clause 1A in Section 3 of the Act. The amended law provides a mechanism for regulation of agricultural foodstuffs, namely cereals, pulses, oilseeds, edible oils, potato supplies, under extraordinary circumstances only, which include extraordinary price rise, war, famine, and natural calamity of severe nature. What is the definition of an essential commodity? Please remember that there is no specific definition of an essential commodity in the Act. However, Section 2A of the Act states that an essential commodity means a commodity specified in the schedule of this Act. The Act provides powers to the central government to add or remove a commodity in the schedule. The center, if it is satisfied that it is necessary to do so in public interest, can notify an item as essential in consultation with the state governments. At present, the schedule contains 9 commodities, namely drugs, fertilizers, okay, foodstuffs, edible oils, hank yarn, petroleum products, jute, seeds of food crops, seeds of fruits and vegetables, seeds of cattle fodder, jute seed, cotton seed, face masks, sanitizers. So recently, these face masks and hand sanitizers have been added in this essential commodities in the wake of COVID-19 outbreak. By declaring a commodity as an essential commodity, the government can control the production, supply, and distribution of the commodity and impose a stock limit. So that was about the Essential Commodities Act, how the recent amendments have an implication on the act. Now, let us look into PM Cares is not a public authority under the RTI Act. So, what is the context for this article? The Prime Minister's office has refused to disclose details on the creation and operation of the PM Cares Fund, telling a Right to Information Act applicant that the fund is not a public authority under the ambit of RTI Act 2005. So, what was the argument put forward by the RTI request? The argument said that as PM cares includes the name, the composition of the trust, control usage of the emblem, government domain name, it signifies that it's a public authority. This is what the appellant has, argued. The composition of the trust is especially enough to show that the government exercises substantive control over the trust, making it a public authority. It also stated that PM is the ex officio chairman of the trust, while three cabinet ministers are ex officio trustees in the PM Cares Fund. So, what now let us try to understand what constitutes public authority, the term public authority under the Right to Information Act 2005. The relevant section of the Act defines a public authority as any authority or body or institution of self government established or constituted by or under the Constitution, any body, authority, etc., which is established by a law made by the Parliament or law made by the state legislatures or by a notification issued or an order made by the appropriate government, namely the central or the state government. It also includes any body owned, controlled, or substantially financed by the government. Also, non government organizations substantially financed directly or indirectly by the funds provided by the central or state governments. So, the debate is whether PMNRF is the subject of public authority under RTI Act. So, there is also this ambiguity which is still existent whether the Prime Minister's National Relief Fund is subject to the RTI Act or not. Okay. The Central Information Commission directed the PMNRF to disclose information in the year 2008. However, a division bench of the Delhi High Court gave a split opinion on the question of whether the Prime Minister's National Relief Fund is a public authority under the Act or not. Okay. So that's why there is still ambiguity whether PMNRF is a public authority or not for the purposes of RTI Act. Next, let us look into the commission to examine the sub-categorization within OBC reservation. What is the context for this? Recently, the cabinet has approved the extension of the term of the commission to examine the issue of sub-categorization of the other backward classes by 6 months. So, what are the details of this? The communities in the existing list of OBCs which have not been able to get a major benefit of the scheme of reservation for OBCs for appointment in central government posts or for admission in central educational institutions are expected to be benefited upon the implementation of the recommendations of the Commission. The Commission is likely to make recommendations for the benefit of such marginalized communities in the central list of OBCs. What is the background for this? The Commission was constituted under Article 340 of the Constitution with the approval of the President in the year 2017. It is chaired by Justice Srimati G. Rohini, who is a retired justice. Okay. So, what is the subcategorization? As you all know, 27% reservation has been provided by for the OBCs, that is the other backward classes. However, you see there are thousands of OBC castes in India cutting across different regions and states of India. So there have been some observations that the reservation policy has benefited only certain number of OBC communities, that is certain number of communities among these thousands of communities, thousands of OBC communities, only a few have benefited from reservation and a majority of the communities have not benefited. So that is why there have been growing demands from certain sections of OBCs that there needs to be subcategorization, that is within this 27% reservation, certain communities which are extremely weaker compared to the other communities, there should be provided more quantum of reservation so that there could be sub-categorization among the major category of OBCs. Okay, that is simply put what is this sub-categorization issue. Next, Bharari Sen, that is Gairsen, the second capital of Uttarakhand. Recently, the Gairsen in the Chamoli district was formally declared as a summer capital of Uttarakhand, and it will be developed as an ideal seat of administration for the state of Uttarakhand. A summer capital is a city used as an administrative capital during extended periods of particularly hot weather. About this capital, Gairsen, a tehsil in Chamoli district of Uttarakhand, is located nearly 270 kilometers from the existing temporary capital of Dehradun. Even when Uttarakhand was carved out of a separate state from Uttar Pradesh on November 9, 2000, statehood activists had contended that Gairsen was best suited to be the capital of the mountainous state since it was between both the Kumaon and the Gharwal regions. These are the regions in the Himalayas. Now, with the announcement of Gairsen as the summer capital, there is a lack of clarity on the status of Dehradun, which is the present temporary capital, and the recently published directory of the State Information Department still mentions this colonial town as the temporary capital. It is expected that the declaration of summer capital in the region will expedite development of the hilly areas. In this context, let us try to understand what was this V.N. Dikshit Commission, which was formed in the year 2001 by the Uttarakhand government to search for a permanent capital. The commission looked into the feasibility of five places for a permanent capital, namely Dehradun, Gairsen, Rishikesh, Kashipur, and Ramnagar, as the state capital on the basis of several parameters, including geographical conditions and population. However, in its final report in the year 2008, it mentioned that the interim capital, Dehradun, is suited to be the permanent capital and rejected Gairsen as it is more prone to earthquakes, but no action has been taken on the report as such. You know, even though the Swian Dikshit Commission has said that Gairsen is not suitable for a permanent capital because it is prone to earthquakes and it is a hilly region of Himalayas, even in spite of this recommendation by VN Dikshit Commission, the government of Uttarakhand has gone ahead by making Gairsen as the capital. Thank you. Have a good day. In the next lecture, we will discuss with other aspects of current affairs for the month of July 2020, namely of economy, okay, international affairs, and likewise. So, students, to download this PDF or the soft copy of the magazine for the month of July, you can download the AKS IAS mobile app on your Android Play Store or Apple iStore, and you can utilize the magazine for preparing for your competitive examinations like UPSC Civil Services examination and the various state public service commissions. Thank you. Have a good day.